Good morning. I'm Simon Lewis, Chief Executive of AFME. I'd like to welcome you all to this morning's members' briefing call on the EU Withdrawal Act. This is a very popular call, which shows the level of interest in this subject. We've seen plenty of political developments on Brexit over the past few weeks. The UK government published its white paper, setting out a more detailed vision of the future relationship, including an enhanced equivalence framework for financial services. We await a detailed reaction from the EU27, but it is clear that the UK government is under significant parliamentary pressure, as a number of key votes in the House of Commons showed last week. In the midst of this continued political ferment and the absence of certainty still about a transition period, member firms are beginning to implement plans ahead of March 2019, and AFME continues to focus on the practical issues you are all facing. This members' briefing call focuses on one very important aspect, namely the UK government's approach to onshoring EU legislation in the UK to ensure a functioning legal framework after Brexit through the EU Withdrawal Act. The Act was passed into law on the 26th of June. It allows for the transfer of EU-derived law in effect at the date of Brexit into the UK legislative framework and gives the government broad powers to make changes to adapt the law to the UK ceasing to be a member state. The government has already started to publish a large volume of secondary legislation. These statutory instruments aim to make amendments to ensure that the law functions effectively post-Brexit. The regulators have also announced that they will be reviewing their handbooks later this year. It's important that the industry considers the implications of changes to the legal framework as part of their planning, and that is the purpose of today's call. I'm delighted now to introduce Chris Bates, who is head of Clifford Chance's financial regulation practice and an expert on these issues. We have worked together on the implications of Brexit for our members pretty much since the referendum, and on this occasion, Chris will provide an overview of the key aspects of the Withdrawal Act and explain what this is likely to mean for firms. Following Chris's presentation, there'll be a good opportunity for Q&A with Chris and our Brexit team, Oliver Moulin and Arvid Cole. Now, just a reminder, you can submit questions for the Q&A at any point during the briefing by clicking on the Q&A icon on the right-hand side of your screen and typing in your question. Without further ado, I'll hand over to Chris. Chris.
Good morning. After 40 years in the EU, EU law has penetrated the UK statute book and the UK legal system in a fairly comprehensive way. And so untangling the UK from the EU is a major legal task, and that is the task the government has given to this Act, the Withdrawal Act. It's important to realise this is only one of a sort of suite of pieces of legislation that are going to be passed to take the UK out of the EU. Not only have we got the Withdrawal Act, we have acts on trade, planned acts on immigration, and a number of other pieces of legislation as well that are passing through the legislative process. And today we expect the government to publish its white paper on the Withdrawal Agreement and Implementation Bill, which will deal with the proposed withdrawal agreement and its implementation in the UK. And it's important when thinking about the Withdrawal Act to realise that the Withdrawal Act is primarily about onshoring UK legislation in the event of a no deal or at the end of or for the end of a transition period under a withdrawal agreement. Is not primarily about dealing with the process of transition itself, although as we'll see there are some powers in the Act to do this. So the objectives of the bill as introduced and the Act as adopted are threefold. It's to repeal the European Communities Act 1972 with effect from Brexit, to onshore EU law, to domesticate EU law, as it's sometimes called, into UK law with effect from Brexit as this new body of retained EU law we'll talk about, and to give the government very wide powers to remedy the deficiencies in that body of retained EU law that result from Brexit. A lot of that EU legislation will just not work in its current form once the UK is no longer a member of the EU, member state of the EU. Now, The bill took about 1 year to pass through the legislative process, and looking back, you can't say, as the Prime Minister was fond of saying, nothing has changed, nothing has changed. But in fact, very little actually changed in the process of the Act. We added about a third of volume in terms of numbers of pages, but substantively, the core elements of the Act, of the bill, remain in the final version. But we did see some major changes, some more parliamentary control over the Brexit process itself. We'll come back to that, the meaningful vote issue, but also more powers for Parliament to control the way the government uses its powers under the Act. More protections for retained EU law to preserve parliamentary control over future amendments, and a lot of discussion and changes around devolution, which we won't bother with. And in fact, when looking at the Act, all 100 and so pages of it, you will realise a lot of it is about the devolution settlement. But from a financial services point of view, you can broadly skip those bits. So let's go into the sort of body of the Act itself and what it tries to do. Well, firstly, it tries to repeal, well, it does repeal the European Communities Act 1972 on exit day, with this commendably short section 1. This term exit day, which pervades the Act, is defined as the 29th of March 2019 at 11 p.m, the date the treaties ceased to apply to the UK as a result of the giving of the Article 50 notice. There are provisions to allow that to be changed if the UK leaves the EU at a different time. But as you can see, this is, again, coming back to the point I made, this is fundamentally about the UK leaving the EU in March 2019 without any form of transition. So the next sort of set of things that the Act does is to focus on this body of retained EU law with a view to onshoring it as part of domestic law. And to do this, it firstly creates this new concept, retained EU law. And when you look at that, you can see it breaks down into 3 components. The first is EU-derived domestic legislation, and that's sort of pretty easy to understand. It's a whole raft of measures, either statutory instruments adopted under the European Communities Act 1972 to implement EU directives, parts of such as things like the Financial Collateral Directive regulations, parts of FSMA or Financial Services Markets Act itself deal with EU law, the laws on controllers, for example, or UCITS, sort of the material in EU Acts, and of course vast bodies of other secondary materials such as the rules of the regulators. All that is sort of treated as EU-derived domestic legislation. The second piece that falls to be onshore is retained direct EU legislation. These are basically the regulations, either level 1, the regulations like EMIR or MIFIR or CSDR, or all the other acronyms which we know and love. Those are all converted into UK law as retained direct EU legislation. But this also encompasses a set of the tertiary legislation, such as binding technical standards, RTS, ITS, delegated acts, and so on, that take the form of regulations and directly applicable. Those are all part of retained direct EU legislation. And then the third bucket of retained EU law is sort of other EU rights, powers and liabilities that operate in the EU in the UK as a result of the ECA, as a result of the 1972 Act. And then that's interpreted by retained EU case law and general principles of EU law. So that's the sort of body of retained EU law, and that's sort of onshored through 3 main sections. Section 2, which deals with EU-derived domestic legislation. And you could say, why do we need to do that? That's already part of UK law. Well, some of it would have fallen away if we didn't have the Act. So, for example, the repeal of the European Communities Act would have repealed all the statutory instruments that were made under it. So if you want to keep them in place, you need to do something to do that. But other things like PRA rules and FCA rules don't disappear as a result of the repeal of the ECA. But nevertheless, the purpose of Section 2 is to confirm their continued existence notwithstanding that their reason might otherwise have seemed to cease to exist. More obviously, there was necessity to onshore direct EU legislation because that only had effect in the UK as a result of the European Communities Act, and so the repeal of that act would have ended the operation in the UK of MEM, REPEAL, all the other acronyms would have ended, and so those have to be converted into domestic legislation at the point of exit. Importantly, only those pieces of legislation, or they're only converted into domestic law to the extent they're operative as at exit day. That means in force and applicable. And of course, there will be many pieces of legislation, such as the prospectus regulation, whatever, which are sort of in transit, in flight, but not fully in force and effect, or the clearing obligation not in flight and not fully in effect, which will otherwise those bits that are not in effect will not apply in the UK and will have to be dealt with under existing powers. And then the final bucket is other powers, rights and liabilities, and those are continued under Section 4. As regards the interpretation of these rules, well, they continue to be interpreted in accordance with existing case law, but future case law no longer binds in the same way. And although they can take it, or the courts can take it into account, they are not bound by future case law. The courts are not bound by future case law in the same way as they are ECJ case law in the same way as they are today. And then the other point to note, of course, is that the ending of the UK's membership also ends the supremacy of EU law. So future acts of Parliament and future legislation can prevail over prior EU legislation in a way that it can't today. The whole point being in the EU is we have supremacy of, from a legal perspective, the supremacy of EU law prevails over domestic legislation, and that will cease going forward in the UK. Now, there are a number of other exceptions where we don't carry forward parts of things that were established parts of EU law. Now, the right to Frankovich damages, the Charter of Fundamental Rights, rights to challenge certain rights to challenge EU instruments, and so on. So, although this body of EU law is the same, it is not the same in a fairly material way. This is a domesticated version of EU law which ceases to be identical the minute the UK leaves the EU, and that's before we start amending it to deal with the deficiencies that would otherwise arise. The other point to focus on is the status of this EU law going forward. And one of the Parliament's concerns was to ensure that the return of sovereignty to the UK as a result of the exit from the EU effectively didn't result in the government being given large powers to effectively legislate through secondary powers in the area that the EU had power to legislate. So the aim has been to effectively restrict the government's powers to amend retained EU law, putting aside the powers to deal with deficiencies, but sort of going forward in the longer term. And the first and most obvious example of this is that retained direct principal EU legislation, that's broadly level 1 regulations, are treated pretty much the same as if they were UK primary legislation, and after exit day cannot generally be amended except by an act of Parliament. So that means things like CRR, EMIR, MIFIR, all those things are effectively unamendable until there is an act of Parliament. That's one of the reasons why we talk about this sort of thing of sort of legislative sclerosis. Well, the UK's law will actually be very difficult to amend. The UK Parliament only got about 30 acts of Parliament a year, most of which are very little to do with economic regulation. So retained EU direct principal legislation treated pretty much as acts of Parliament. Now, what they call minor EU legislation, which is broadly the level 2, RTS, ITS, delegated acts, and so on, can be amended more easily. And as we'll see, there are going to be special arrangements for financial services legislation, which will make those more amendable at a secondary level, but the primary legislation remains the same, as does at the primary level 1 regulation remains the same, as does statutory instruments under the European Communities Act. Things like, as I said, the financial collateral regulations or the payment services regulations, all of which pretty much become unamendable except by Act of Parliament or a future Act of Parliament which seeks to tidy this up in some substantial way. But of course, the other feature of the Act was that it focused on the reality that much of EU law really just won't work if it's domesticated in terms. And so the Act gives the government a very broad power to remedy deficiencies, exercisable banking regulations under the Act for a period of up to 2 years after exit day. And the minister can make secondary legislation, regulations to make provisions, any provisions the minister considers appropriate to prevent, remedy or mitigate any failure of the retained EU law to operate effectively or any other deficiency in retained EU law arising from the withdrawal of the UK from the EU. Now, I mean, there are a few things to note about this. Firstly, this continues the original proposal, government's original proposal, that the minister can act where it considers it appropriate to remedy deficiencies. There have been proposals to amend that to make it only exercisable if the minister considered it necessary. So that's a very broadly phrased power. Secondly, the power to remedy deficiencies is to remedy deficiencies that arise from the withdrawal of the UK from the EU. It's not to remedy deficiencies because the minister doesn't like the EU law or doesn't think that it is policy appropriate for the UK as a non-member state. These are the focus of this is on powers to remedy deficiencies arising from withdrawal, not generally fixing things that people may or may not like about EU law as it stands today in the EU. But of course, that's nevertheless, it's a fairly broad power. There is a list of what, closed list of what, when legislation would be considered to fail to operate effectively. And you have obvious examples such as legislation which refers to bodies which will no longer have authority in the UK, like ESMA, or the EBA, or the European Commission, or references to processes which will no longer be relevant, such as arrangements for consultations with those bodies. And importantly, another feature is anything which relates to reciprocal arrangements. And as we'll see, this is one of the sort of key elements of the change that will occur as a result of the UK's exit, is that all the arrangements which depend upon effectively reciprocity, which of course is at the heart of the EU legal system, will go. And to sort of foreshadow what I'll say a bit later, the government intends to use these powers effectively to say, well, the EU is going to treat us as a third country. We will treat the EU in the same way under our implementing powers. And obviously that makes has a whole range of impacts across the financial services sector, where a lot of EU legislation is sort of interrelated with that idea of reciprocity. The powers are very broad. They can be used to make any provision that could be made by Act of Parliament, famous what were called Henry VIII powers. There are some limits. They can't be used to impose taxes or fees, or increase taxes or fees, make retrospective provision, create certain types of criminal offences, establish public authorities, amend the Human Rights Act, and some other provisions about devolution. But those are fairly unlimiting limits on the government's power to amend existing EU retained EU law, UK law that relates to EU matters. The key issue that sort of took up a lot of time in Parliament was, how does Parliament control this process? Because this is a very extensive process. I mean, the government has talked about 800 statutory instruments and as anybody's looked at any of the ones that have been published so far, will see of some degree of complexity. So how does Parliament control this? And the idea is that, broadly speaking, there'll be two types of controls. Some types of instruments will be subject to affirmative approval of both houses of Parliament, and some to negative approval, i.e. They're laid and come into force if Parliament doesn't object within a period. And there'll be a sort of parliamentary sifting committees to play a role in determining which process applies to which particular piece of legislation. One thing that did go missing in action during the bill was what used to be a provision about international obligations. There used to be a separate provision giving the government power to prevent or remedy any breach of the UK's international obligations arising from Brexit. That's not, didn't make it into the final act. And I don't think the government thinks that's a problem, because I think it thinks that if the retained EU law breaches its international, the UK's international obligation, that's pretty much a deficiency which will need to be remedied. And most of those will flow from the reciprocal arrangements, which might otherwise violate UK's most favoured nation obligations. So that's sort of gone, but not gone. The other set of powers that sort of that received a lot of attention in the legislative process was what is now Section 9 about implementing withdrawal agreement, and this gives ministers the power to implement the withdrawal agreement up until exit day, so to adopt, to amend UK law and to do other things to implement the withdrawal agreement if it's necessary, if the minister considers that such provisions should be enforced on or before exit day. Again, a Henry VIII power to do anything that could be done by Act of Parliament, but they can't be used to do, broadly speaking, the same range of things you can't do under Section 8. The key limitation that was imposed during the process was nothing can be done under this unless there's an Act of Parliament approving the withdrawal agreement, in which case you sort of wonder why we would need Section 9 at all, because surely the Act of Parliament would give any necessary powers. So I think this has sort of become a bit of a sideshow, and we'll see more today when we see the white paper on the Withdrawal and Implementation Bill, handily known as WABE, for those wondering why people are talking about WABE. The other point, sort of pick up on something that I mentioned earlier about the impact of transition is just to remember that this is fundamentally about leaving the EU without a transition period, and so we have to think, well, what would happen if there is a transition? Well, first thing is to understand what the transition period would mean, and of course we do actually know what both parties actually think how a transition period would operate, because we have agreed draft text for the withdrawal agreement, which was published a few months ago, and the text for the transition period, which calls the transition period, actually mentions the word implementation period, the government's preferred wording as well, but fundamentally defines it as a transition period. And all that was marked green and broadly agreed between the parties. And so the agreed text makes clear that during the transition period, the UK and the EU will continue to apply EU law as if the UK was still a member state, including all the new EU law that might need to be implemented during this period up until the end of December 2020. The UK, the main difference in status between the transition period and today is the UK would cease to have any of its institutional rights, its rights to participate in the EU institutions and its voting rights in those institutions. And so effectively the UK becomes a sort of, you could say, a bit like Norway, but more so because this is the full panoply of the single market, including the customs union and the customs union, and pretty much everything else, with some other not so material exceptions. And so if we have such a transition period, you can see that the idea of onshoring EU law in March 2019 doesn't really make any sense, because from March 2019 to the end of 2020, EU law is supposed to sort of apply pretty much as it does today. So we can't go around not applying it or applying it in a different way. So what would happen? And of course, as I said, there are powers under Section 9 to provide for the continued acquis, so they could use those powers to implement EU law in the transition period. They could use powers under Section 8 effectively to defer any legislation that has been adopted, and there are some transitional powers under Section 23, but more likely we will have some provision made via WAVE to deal with transition. Actually, one of the interesting points about the withdrawal agreement that was not marked green was how the UK is actually going to implement its provisions in domestic law. You know, that is a subject which the UK has not yet agreed with the EU, and the EU and the UK might have different ideas. I mean, I think the EU's idea would be, at least during the transition period, we'd have something that either Section 2 continued of the European Communities Act, which I think would be highly controversial politically, or something that pretty much did the same thing. The government might have different ideas, but it's difficult to see how you could preserve EU law as part of EU law during the transition period, as part of UK law during the transition period, without something like that to give it the same legal effect. So let's turn to sort of onshoring into the UK, the EU financial services legislation. And I think it's worthwhile starting with this idea of delegation, which the government has talked about, and is actually one of the very first of the statutory instruments to have been published. This is the Financial Regulators Powers, Technical Standards Amendments, etc. EU Exit Regulations 2018, which have been laid subject to approval of both houses of Parliament last week. And those who get our weekly updates, our daily updates through our alert service, we are publishing a weekly update which will highlight the main financial services or relevant pieces of EU legislation. On Friday there were 4 last week, and this was one of them. And so the what this does is quite interesting. The first thing it does is effectively delegate to the UK financial sector regulators the power to remedy deficiencies in binding technical standards. They may also give them some powers for things beyond binding technical standards, like some elements of delegated acts, I think they've talked about as well. And they will be given this power to adopt what are called EU exit instruments in order to do this. So effectively, they have the same sort of powers as they'll be able to use their rulemaking powers, which are given to them under this, the quasi-rulemaking powers under this statutory instrument. They will also be given powers to use EU exit instruments to remedy deficiencies in the EU-derived provisions of their own rules. And you might say, well, why do they need that? Because they can amend their own rules anyway. They don't need any special power to do that. But of course, if they were amending their own rules, they'd be subject to a whole range of procedural restraints, including such things as cost-benefit analysis and consultation requirements, which the government considers would hamper their ability, the regulators' ability to actually do what they need to do in time. So effectively, the purpose of this is to free them from those constraints, to amend their own rules, and they will not be subject to those constraints in relation to fixing the deficiencies in binding technical standards either. And there is a sort of element of Treasury control. The Treasury can veto these instruments subject to Treasury approval, and they can veto if the Treasury considers that they don't comply with the requirements of the Act. So this is quite important because everybody's talked about 800 statutory instruments, maybe 100 to do with financial services. But of course, actually, the real body of stuff that we'll all have to look at is not just the statutory instruments. It will be this range of EU exit instruments, which will effectively transform the rulebook. So anybody's opened any of these rulebooks recently, and just thought what needs to be changed, will realise that a lot needs to be changed. And the rulebook is littered with references to the EU and EU measures, which will be changing in some shape or form as a result. And the regulators have said that they will consult on this in what they're doing in the autumn. So even though they're not constrained by consultation, they still nevertheless plan to consult. The other thing that the rather lengthily named regulations do is aim to create a framework under which the UK regulators will have ongoing powers to make and amend technical standards using what are called standards instruments. This isn't strictly about onshoring, but is about the consequences of onshoring. So the individual amending statutory instruments that, for example, amend EMIR or CRR, all these things, will also deal with the question of who has the powers under those regulations to make binding technical standards, and they will effectively, the aim is to effectively point those powers, delegate those powers via the statutory instruments to the UK regulators, and then the amendments made by the exit regulations, these EU exit regulations, effectively put a framework around that. So you effectively have to read the original EU legislation, the amending SI, and the amendments made to the legislation through the exit regulations to get the picture. But broadly speaking, the aim is to allow the UK regulators the ongoing power to make binding technical standards in future and to amend the ones that there are. For this, they will have to follow their existing rulemaking processes, except that the Treasury, who doesn't have the power of veto over any existing rulemaking powers, because the regulators are independent, will have the power of veto over these instruments, because if they have implications for public funds or would interfere with international negotiations. So this is sort of puts these amendments, these rulemakings, in a sort of different category from other rules that the regulators make. The other, just while talking about this, is just worth thinking about, well, that's not the whole of level 2, because there's a whole range of measures, delegated and implementing acts, which are not binding technical standards. So, people will be aware of the binding, the delegated acts under MiFID II, MiFIR, and so on. And the question of what happens to those, and I think that the implication is that those powers will be also retained at a secondary level, but given probably to the Treasury to make those delegated acts sort of going forward. So the sort of level 2 powers will pass over as sort of secondary powers in the UK. The other thing which there's been quite a lot of discussion around is level 3. Level 3 is all the Commission and ESA guidelines, recommendations, FAQs, opinions, and all the other work that is done by the EU bodies to sort of coordinate and converge supervisory and regulatory practices under the EU legislative framework. And these are not part of retained EU law, because they're not, almost by definition, they're not law. And so they don't pass into the UK law in any way. Obviously, the UK regulators can choose to continue to apply those measures anyway. I mean, there's nothing that prevents them doing so. Of course, the UK regulator attitude to this stuff varies. So in some cases, they're required to say whether they are applying it or not. So recommendations and guidelines, the UK regulators will have said, do we apply these today or not? Sometimes they do, sometimes they don't, when they feel constrained by domestic legislation. FAQs are more interesting. I mean, in many cases the UK the regulators do apply the interpretation of the FAQs, but sometimes they don't. They don't always tell us when they don't either. We can expect, in a way, what you would expect is they would continue to give this level 3 body of material the same attention as they had previously. I think it'd be helpful if they actually said so, because I think that would give people some comfort, and I don't see there's any constraint on them saying so. But they haven't as yet said what they're going to do with it. Perhaps we'll learn more in the autumn. So what is the sort of general approach to onshoring? And I put up this quote, which is quite interesting, from the paper. This is the Treasury paper on the approach. It's an approach paper published a couple of weeks ago now. Firms do not need to prepare now to implement onshoring changes in the event no deal is reached with the EU. I mean, in some senses, this is clearly correct. The government, they are seeking to say that what their preparations for no deal are designed to minimise the need to take any action. So, although the UK will default to treating EU member states in the same way as it treats third countries, the UK plans to, the Treasury plans to do things to mitigate the impact of that. And it will do that through, most prominently, the temporary permissions regime. So firms that are passported in that will no longer be eligible for passporting, because passporting won't exist, and the EU will be treated in the same way as the United States or Peru. There will be a temporary permissions regime to effectively allow firms to operate for a period after Brexit without getting permissions and time to apply for full authorization. And that's obviously most relevant in the case of firms operating through branches. And the Treasury has also said that it plans to do other transitional regimes and to give regulators general power to phase in post-Brexit rules. But the idea that going back to the catchphrase, nothing has changed or nothing will change on exit day, I think is overstating it. And I think this comes back to the point about preparation. The key point is that something will change, and the question is what. Firms are, I often say strangely, have policies about complying with the law, because they take, firms take compliance seriously. That's what regulators expect. And so if something changes in a way that they have to do something, firms will feel constrained to actually do something about it. And I don't think it's possible at this stage to say that at the point of exit, if we exited with no change on, with no deal on March 2019, that firms will have to do nothing. You just have to think about rules like the rules about depositor protection for branches. The moment the UK leaves the EU, unless the EU does something, the deposits at London branches of EU banks will cease to be covered by the domestic schemes. Okay, so maybe they'll be covered by the UK scheme, but the UK scheme is different. Firstly, it's got a different quantum, £85,000 rather than €100,000. So, does anybody have to tell the depositor? Now, you could affect that. Maybe the UK will say, well, we'll make it 100,000 for some interim period, so that will, diminish the effect, or, But you can see, just taking that one example, that the idea that nothing will change is somewhat optimistic in a way. And of course, I think the other concern about this whole process is that the volume of work is very, very large, so that actually reviewing this material is very will be a very demanding process. There will be relatively limited opportunities to consult. The government has sort of indicated it will do something about consultation. You know, the regulators have indicated they will do something about consultation, but the practicalities of the timetable mean there are relatively limited opportunities for the government to consult. And so identifying within this body of materials things that matter to you or to firms generally is quite a challenging process. So we can perhaps come back to that in Q&A. Just finally then on the Act itself, I mean, just a bit about the parliamentary approval. I mean, there's perhaps a lot on the slide, and I mentioned on the first slide, and you have these slides and links to our client briefings on this, which can provide more information. So, you know, we don't perhaps need to dwell too long on these issues, because I think it's more political rather than practical. But you can see that, you know, we've ended up with quite a complex set of measures designed to try to ensure that Parliament has a meaningful vote on the withdrawal agreement and withdrawal arrangements, and some idea that the Parliament will have some element of contribution to direction if there's no agreement on the outcome by the 3 months before, sorry, 2 months before the final date. But I don't think we should dwell on that in the time available. We could probably go to questions. I'll hand back to Oliver and Simon.
Thank you, Chris, very much for such a comprehensive, informative and wide-ranging presentation. We have about 15 or so minutes for questions and comments. Just a reminder for those on the line, you can submit questions anytime. You can just click on the Q&A icon on the right-hand side of your screen and type a question. We actually have 3 questions already. So I'm going to kick off with those, if I may, Chris. First question. Do you know the number of financial services related pieces of legislation that require domestication and roughly how long it will take to fully domesticate them? There's a very specific question. And I'm going to move on to another one maybe. Yeah. A quick answer to that one.
Answer. I don't actually know the number of pieces of legislation that, you know, there are various estimates around how much legislation there is. And of course, the other point is that a lot of this is not in one place. So all the stuff about MiFID is not just in MiFIR. There's all scattered across rule books, FSMA and other pieces of legislation. So it's quite difficult to identify. I mean, I think the more meaningful point is there, you know, this estimate of 100 statutory instruments required, and those will cover, you know, thematically groups and bodies of legislation, or sometimes, you know, possibly, you know, more than one statutory instrument being required for a particular sort of EU dossier. But, you know, that gives you some idea of the scale. And then, as I said, you know, these EU exit instruments, which will be, you know, pretty significant. I mean, if you look at, you know, MiFIR, for example, I mean, you know, the level 2 under MiFIR runs to, you know, 3 or 4 centimetres of material printed out, and that needs to be worked through. So the answer is broadly a lot. In terms of how long it'll take, I mean, they plan to do it by March. You know, they plan to put in place the legislative powers to domesticate EU law and have it in place by the end of March. And so that if the UK leaves with no deal, either because there's no deal reached or because it's not ratified, then the UK will have some kind of functioning statute book and rule book and a regulatory rule book with some additional powers to deal with issues being delegated to the regulators on top of that, but all in place by March 2019.
Thank you. Just a quick supplementary, because we've had quite a few questions from members about the statutory instruments and whether, in effect, for each SI there'll be an opportunity or there's a consultation period attached to them. If so, what would your advice be? Is it something that the industry should be thinking about contributing to as the SIs are made?
Well, there's no formal requirement for consultation. I mean, and once the SI is laid, you have to remember that Parliament scrutiny is only, to the extent Parliament has scrutiny, it's a power to reject or not approve, depending whether it's negative or positive approval. So Parliament has limited ability, and therefore firms have limited ability to control that. But, Oliver, perhaps you want to come in on what the government's talking to the industry about.
Yes, thanks very much, Chris. I mean, perhaps just to add a little bit on that, I think what we're expecting is, although some of them have formally been laid before Parliament, given the recess is about to start, the government's likely to publish in draft form a number of statutory instruments over the summer, and there will be an opportunity to at least look at those and potentially provide any feedback ahead of them formally being laid before Parliament, when Parliament reopens in the autumn. So there may be a bit of a window there for commenting.
Thanks, Oliver. And whilst you've got the floor, any sort of other observations you would want to make on Chris's presentation, I suppose particularly in relation to the work that we're doing with our members on Brexit?
Yes, perhaps just to give a bit of an overview as to how AFME is approaching this. I mean, as Chris has mentioned, clearly there's going to be a very large volume of legislation that will, could potentially have an impact on financial services law for those operating in the UK. As I said, we're expecting a number of statutory instruments now to be published over the summer before being formally laid in the autumn, and I think there will be further ones obviously ongoing throughout the year. So there will be an opportunity to sort of review those and potentially provide any feedback. We have been liaising with the government, the Treasury, and the regulators, in particular in relation to sort of cross-cutting issues and the process, and things like the statutes that Chris mentioned around the division of powers between the government, the Treasury, and the regulators. But in terms of how we will be looking at the SIs going forward, we'll really be utilising our existing committees where the expertise currently sits to consider sort of priority issues within AFME's scope of focus. Some committees have had some initial discussions with the government or the regulators as to how they might approach certain issues under the whole Withdrawal Act process. But really, I think what we'll be doing is coordinating closely with other associations to try and minimise duplication for members and focus on those areas most pertinent to AFME. Perhaps just one other thing that I'd mentioned just on the last question, actually, in terms of Chris, the question about timing and how when we'll actually see all these SIs. I mean, one question which I think arises, which will be quite challenging, is legislation that's currently going through the European legislative process, but may be finalised pre-exit day. So things like the revisions to CRR2, for example, which may or may not be in the official journal relatively early next year, potentially. There'll be a very limited window in which to have an SI that adapts that before March 2019. So I think there will be particular challenges, and hopefully some of the transitional measures that the government has said that they will be proposing will be sort of important there. But also the need to look at things like what will be in effect and operative on exit day and what will not be, going back and sort of looking at what's going to happen for things which come in, if there are provisions which come into effect shortly after exit day, what is the process going to be up there, and which the government hasn't yet clarified.
Thanks, Oliver. I mean, another interesting question, Chris, has just come in. If I can ask this now, what's the legal status of the withdrawal agreement in EU member states? Presumably, it's directly effective there with no domestic implementation necessary, such that other member states would, without more, continue to apply EU law as if the UK was still a member state.
Yeah, no, it's a very important point. You know, the way the withdrawal agreement is written assumes that what has been said is correct, and I think it should be correct. There's a sort of general principle of EU law, the international agreements. There's a common distinction between what are called monist states and dualist states. The UK is a dualist state. Doesn't mean we observe some ancient Manichaean heresy, but it means that we have this rule that the international agreement is only part of domestic law when Parliament has acted, whereas monist states like Germany and other countries, international obligations directly form part of domestic law, and the EU is such a as a legal system is like that, and so international obligations like the withdrawal agreement should be directly applicable in the member states if they meet certain criteria such as precision, intended to confer direct rights, and so on. So the core point of the withdrawal agreement that the question refers to is this provision that says that member states must apply EU law as if the UK were a member state, which is just, sort of one tiny sort of set of words embedded in the middle of, a lot of other wording, but that's the key bit. Actually, it changed slightly from the first draft. The UK strengthened it, I think, to make this point clearer. The member states must apply EU law as if the UK were a member state, not just the UK, and therefore, during the transition period, with the limited exceptions that are set out in the withdrawal agreement, the single market rights continue. Of course, the other point to bear in mind that only affects the EU. Other states don't have to apply. You don't have to treat the UK as a member state. So if you have other systems of law, that refer to EU rules being binding or whatever, they don't have to say, oh, well, the UK is no longer a member state from their point of view. That's a question of construing the relevant domestic CFTC rule that recognises, gives equivalence treatment effectively to EU based on the application of EU requirements. But that's a sort of one important exception to that, and so it's most obviously relevant in trade agreements, relevant, for example, to the insurance agreements in place going into place between the UK and the EU and the US. But it's also relevant in the derivatives area because we have some other systems of law which recognise aspects of EU compliance as being sufficient for various purposes. And so, the question will be, do they regard the transition period as delivering the same thing? And that'll be a question of US law, Japanese law, whatever other legal system is applicable. And this is, we believe, one of the items that the UK regulators are focusing on, although we haven't seen any external visibility of that. And I think that's something which people will want to engage with them on.
Thanks, Chris. We're coming towards the end of the session. I'm conscious, actually, we've got a few questions still outstanding. So can I encourage anyone who wants to ask a question to ping an email in now? We'll try and cover the questions, but I'm not sure we're going to. But just to thank you for your questions so far. Big obvious question next, Chris, in relation to the onshoring of EU law. How should financial firms be preparing for these changes now?
Well, the first thing is you have to anticipate what those changes are. And so, the most obvious group of people who are clearly preparing for this are EU firms with branches here. Those are clearly affected. They are clearly applying for, or being encouraged to apply for full authorization in the same way as if the UK was leaving the EU. But they need also to consider what sometimes we call the regime shift, those points that I mentioned about how rules change, and think, well, if those rules change, what do we need to do? I think the other thing that the other group of things I think people will be concerned about is potential changes to reporting and other arrangements, to the extent that those might affect firms, and also, people will be thinking about their own documentation. I mean, I would expect the impact on documentation. This is not just documentation for EU27 business, but other business. You could probably get by, but you probably need to think about your documentation and think, to what extent is it EU law dependent in some way, and therefore do these changes impact it, and therefore do I have to think about changing that documentation? I mean, that's an interesting and sort of separate from repapering EU27 clients. This is, well, what about other clients?
Next question is about approvals, which is obviously highly related to timetable. And the question is, does the EU withdrawal agreement have to be approved, ratified by national parliaments in the EU27, including regional parliaments where necessary? This is obviously very much related to what Michel Barnier has been saying about what he needs to do to deliver it from the EU27 point of view. What's the position in terms of approvals required?
Well, the answer to the question is no. The withdrawal agreement requires approval on the EU side by the European Council after having obtained the approval of the European Parliament, but it does not require approval at a member state level. And then in the UK, it needs whatever the withdrawal agreement says, and the government had made various statements about how it intends to handle the UK process. But it's clear we're going to have a separate act. We'll have a meaningful vote of some kind, and so on. But the primary concern: do we need to run round, the Walloons or all the others? The answer to that question is no. That issue will arise with respect to the long-term agreement that will be negotiated. The aim is negotiated and concluded during the transition period. Some aspects of that may require approval, not necessarily if it's an association agreement. But that's an issue for tomorrow, not for today.
And before we turn to the last question, Oliver, are there anything you want to sort of flag up in terms of work that we have in the pipeline from an AFME point of view that members should look out for in the next period?
No, I think there's a few things that will come out of the secondary legislation that will be important for us to focus on, including the sort of temporary permissions regime, and greater clarity there for the EU27 base banks in particular. Also, the government announced that they will be bringing something forward in relation to grandfathering of existing contracts, allowing those to continue in the UK. And obviously, we're focused very much as well on the position for the other way around in terms of the EU27 clarity there. So I think there will be a number of things, as well as the sort of looking at the differences from treating the EU member states as third countries and what implications that has for documentation, the other things which Chris mentioned. There will be a few more fundamental, perhaps, points that we'll need to look at closely with members.
Okay, and again, with apologies that we haven't been able to cover all the questions. That is pretty much a record number of questions we've had on this call. So thank you all for your contributions. I'll leave this zinger to last for us, which is, do you have a view, any thoughts on the Supreme Court case over the Scottish Brexit bill?
No.
Well, that gives us time for one more question, which I think, and that's a very clear answer. And I think we've got a question about privacy, I think, haven't we, somewhere? Here we go. Let's try this one. How will the upcoming e-privacy regulation be transposed into EU law? Will there be an effort to maintain adequacy?
The answer is we have, I don't remember whether it's actually passed into, the act has been passed. I think it's actually been passed out of the UK legislation, haven't it? And so we have a UK Act of Parliament, of the UK Act of Parliament doing this, but that was happening sort of anyway. And so, but on top of that, we will need, that Act of Parliament was designed originally around the UK being a member state, not being out. So there will have to be a second layer of action, I think, under Section 8 of the Withdrawal Act to address any deficiencies that arise from that, with a view to maintaining adequacy.
Yeah.
Oh,
so
do you want to comment on that?
Just on the broader question around adequacy and the ability to continue to transferring personal data is something that we are picking up through our advocacy, both with the UK and the EU27. We did publish a paper a couple of months ago now, sort of looking at this in a bit more detail. But at the moment, the position is from at least the EU side, although they will be looking at potentially adequacy in the future for the UK, they'll need to go through the necessary processes. If there is a transition period, that may be easier because the UK will be a third country and there will be a period in which they can make that determination. I think it's much more challenging to have that in place or have sufficient clarity that will be in place for an exit within no transition scenario. So I think their certain position for the EU at the moment has been that firms should still plan on the basis of no transition, and like everything else, can't rely on an adequacy position being in place, and therefore need to look at the mitigating actions they can take. But it is something that we're continuing to address.
It's just worth mentioning, because this is an important general point. It's not really about the UK, it's more about the EU side. It's what I've sort of started calling a hiatus risk issue, that yes, the EU, I say it plans to treat the UK as a normal third country, and normal third countries, at least third countries that are well regulated, benefit from, or the EU people dealing with them benefit from a whole range of equivalence and other adequacy and other decisions about risk weighting or recognition of CCPs, obviously more controversial, but a whole range of things. The issue is there's no clarity at the moment about when those would be available, either in a hard Brexit in March or at the end of a transitional period. And how do you avoid this issue of there being a gap within, where these arrangements don't work, where benchmarks, UK benchmarks, the UK benchmark providers are not, obtained recognition or endorsement, or the UK credit rating agencies have not been had their ratings endorsed and so on. And you can't but think that that's as much an issue for the EU, and the UK is trying to deal with the issues in reverse through the withdrawal agreement, but we've no specific proposals from the EU how the EU side is dealing with those issues in the interest of its own firms who might otherwise have to stop using LIBOR or whatever it happens to be, with effect from the date of exit. And this is the sort of mysterious sort of preparedness action. Yes, I think the EU keeps talking about preparedness being a matter for the private sector, but there's a whole bunch of things where it's indisputably a matter for the official sector as well. And so far, the talk has been, yes, we will have a hiatus. That just doesn't seem credible in the interests of its own firm.
Thank you, Chris. And I'm going to have to close this call now. Thank you very much indeed, Chris, for joining us. An excellent presentation and for covering so many different and varied questions so fully. Thank you to the team here for arranging the call, to Oliver and Arvid. Very interested as always in your feedback. These are obviously member-driven calls. If you would like to sort of see the format change or development, do let us know. But we really appreciate the fact that so many of you dialed in. Sorry we didn't cover all the questions this time, but thank you for your attention and enjoy the rest of the day. Thank you.